and what the minority is saying. You heard Alexander Fenyoma make that particular point. Already, we know the process is in place or ongoing. As far as we do know, the Chief Justice has responded to the petitions against her. The consultation with the Council of State, as enshrined in Article 146, is ongoing by the President. As to whether a prima facie case has been established or not, it is not public, so we do not know, even though there's been some publications pointing to that effect, and the minority also referencing some allegations that they say is contained in the petitions against the Chief Justice. But how things have played out, and especially the concerns that have come up, does it have any merit in there? Because I just want to run up on this aspect of the conversation because it ties directly into the current state of affairs. Is there a real challenge that this call for the review of these powers will solve? Council?
I think that we are faced with an issue that we should not confuse matters. What we are discussing this morning relates to a press conference by the minority leader. He calls himself the mighty minority leader. What that means, I don't know. But what is not in doubt is that the minority leader says that there is an unacceptable attempt by the NDC to infiltrate the judiciary, and now says that civil society groups must condemn that act. And not only that, he invites all other persons, religious leaders and what have you, to tell President Mahama to stop what the Constitution says he should do. Article 146 of the 1992 Constitution is in clear terms. Thankfully, our Supreme Court had the opportunity to interpret Article 146 on the removal processes, particularly as it relates to a Chief Justice. Question: has President John Dramani Mahama done anything today not stipulated by the 1992 Constitution? Certainly the answer is no. Now, President Mahama, having assumed the office of President of the Republic of Ghana on the 7th of January 2025, has received 3 petitions. The petitions are to the effect that, based on the constitutional arrangement, the only basis that you can remove the Chief Justice or a Justice of the Superior Court is 1, through stated misbehavior, incompetence, or infirmity. As I speak to you now, I have not had the benefit of seeing the content of the petition. I have not seen it. Because if you recall, the Supreme Court in Franka J. Chum had provided a certain parameter that the entire process should be kept in camera. Strict confidentiality. So President Mahama, guided by this decision of the Supreme Court, has kept the petition under wrap. In fact, if you recall, when Her Ladyship, the Chief Justice, wrote to him, however, copy to the Ghana Bar Association, Association of Judges and Magistrates, obviously the President expressed his disappointment with that conduct. Her Ladyship, the Chief Justice, demanded of the President, or requested, that Mr. President, I need 7 days to respond to these petitions before a prima facie case can be made against me. The President advised properly, said, yes, even your request for 7 days, I'll give you 10 days. That was offered her generously. Let the record reflect that Afenyo Makin, one of the principal advisors of Nana Addo Dankwa Akufo-Addo on legal matters, did not advise Akufo-Addo to give Charlotte Osei the benefit of these 7 days or 10 days. That is our record. So it is a mark of it. Let me say, it is hypocritical for my leader senior Afenyo Makin to do a press conference and suggest that President Mahama is doing something untoward. It's regrettable.
Well, no, he's not the one who holds that. The argument by the immediate past Attorney General is that to the extent that this injunction application is being heard, it behoves on the president to halt any process ongoing under Article 146 until the determination of that case.
You see, as for Godfred, I won't even talk about him for now. Let me deal with a major issue. You see,
that underlines the position that Macron has taken.
President Mohammed's fidelity to the 1992 Constitution is something that should be celebrated. When he became president, he appointed a Shrad boss called Madame Vivian Loretta Lamptey. Now get something. Honorable Frank Anodompre, MPP MP, and another gentleman by name Richard Nyama brought a petition to President Mahama that the Shrad boss so appointed by him has misconducted herself, financial issues, and therefore we're seeking the removal of the Shrad boss. President John Dramani Mahama, consistent with his character to uphold the rule of law, accepted the petition, forwarded it to the CJ then. The CJ then made a prima facie determination, and the Shrad boss, Madame Loretta Lamptey, then
an appointee of President Mahama
was removed by President Mahama. Consistency. Today, as we speak, President John Dramani Mahama is in receipt of 3 petitions. I don't know the individuals. What has he done, having received these 3 petitions, to warrant that unprovoked, meritless provocation from Afenyo Makin? Has President Mahama done anything inconsistent with the 1992 Constitution? No. He received the petition. The Chief Justice said, President, I have become aware through a press release by your spokesperson, the Honorable Felix Kwachi, that these petitions are in your custody for my removal. Mr. President, before you make any comment further on this petition, Mr. President, I want to respond. The President said, well, I mean, that's fair. In fact, you should have actually spoken to me. Meanwhile, the letter requesting for it, you've copied other people. But that's beside the point. Your request is legitimate. I will give you 10 days to adequately prepare. Now, the president, having done this, was it consistent with the Constitution? Due process. He said, look, let's everything, let everybody, you can't condemn a person without hearing, even though I differ. The president says, I will do that. Now, the Council of State or whoever is supposed to go into the merit or otherwise of it. If the Council of State so advise the president and advise that he is not bound by though, what you do, if he sees that there is a determination of prima facie, you do a 7-member, a 5-member committee comprising 3 justices and 2 quote-unquote civilians to determine whether it merits your removal. In the meantime, the president has the power to suspend you. Now, from the time of the receipt of the petition to date, has President John Dramani Mahama done anything outside the strictures of the Constitution? No. Now, listen carefully.
I just want clarity. I'm told that there had been a ruling that says that if there is a petition against the Chief Justice, the President is not bound to give a copy of that petition.
No, so you see,
I'm just asking.
No, so you see, there were 2 schools of thought.
Okay.
That flowing from the Frank Ajechum decision.
Okay.
There is a lacuna. And that at this point, really, because personally, I think that when a petition comes and you respond copiously, it means that on the face of it, there's something that needs to be looked into. Okay. That's my view. And so I strongly believe that even at this point, the question of giving a copy to the person or respondent here is a bit, the Constitution itself is a bit silent on it. Okay. But President Mahama said, regardless, I will give you the opportunity, and gave her 10 days to respond. Now look at this. Afenyomakin, who addressed the press, one of the principal legal advisors to Nana Addo Dankwa Akufo-Addo until he left office, was here when Madame Charlotte Osei's petition came. Faceless individual. With all the issues, Madame Charlotte said through her lawyers, wrote to Mr. President Nana Addo Dankwa Akufo-Addo for a copy of the petition to respond. Eugene Ahin, the presidential gongon beater, then said, listen carefully, then said, it is not in the place of President Nana Addo Dankwa Akufo-Addo to give Charlotte Osei a copy of the petition. Mahama didn't say so. Mahama said, have it. Madam Sophia Akufo, then Chief Justice, because it relates to, did the Prima Facie determination. Eventually, the president appointed a 5-member committee. My Lord Justice Benning, the late Justice Mafusa, Agnes Doji, Abrampa, and another woman. They went into the merit and said, look, there is grounds, and recommended the removal of Madame Charlotte Osei. It was a 3-2 majority decision. You understand? So that is our record. Has President Mahama today done anything outside what Akufo-Addo has done? In fact, he had even gone a step higher. The lawyer Akufo-Addo was not willing to give a copy of the petition. The non-lawyer John Dramani Mahama respected the request of her ladyship, the Chief Justice, and offered her. She even requested for 7 days. President Mahama. Don't compare President Mahama to
Akufo-Addo. Please, gentlemen.
I understand you are unconstitutionally interfering in the
But I'm saying, if you compare,
so I am saying that. Wait. So I am saying that this attack from the minority, and I've heard my learned senior Daku and the minority leader, I see that Afenyomakin cleverly wants to turn the conversation into an NDC MPP thing to muddy the waters cleverly. And if you heard my national chairman, he said this matter, we are not talking about it, the merit or otherwise. President John Dramani Mahama has so far conducted himself so well, and it's also because he had the benefit of sound legal advice with the likes of the Attorney General, Marietta and co around him. They would not allow the president, even though a non-lawyer, to do anything outside the constitutional stipulation. And so, you see, I think that regardless of the merits of the petition, and I don't want to go into it, regardless of that, I have seen media houses, some other media houses and colleagues say, oh, the NDC wants to remove Madame, what's her name, her Chief Justice Torkono, because either than that, the NDC cannot do oral or something.
And that you don't trust the current architecture of the judiciary to prosecute the oral
cases. Let me tell you. I'll tell you. Hold on. Shouldn't it be? I beg you. I'll give you a classic example. A case I conducted. So there is a judge. I'm enjoying listening to you. There is a judge. My Lord, I'll just use this example. And my Lord Justice Akabuafo, you know him?
Yes.
Okay. Good. My Lord Justice Akabuafo was appointed by President Mahama High Court. Then Nana Addo took him to the Court of Appeal. Right? Yeah. Good. So he strained both regimes. Correct. I did Ato forcing at the appeal before him as one of the Court of Appeal judges. When he saw merit in it, even though he was appointed by President Nana Addo to the Court of Appeal, he saw merit in our appeal. and acquitted and discharged. So for me, the idea that, oh no, because you have been appointed, in fact, her ladyship Justice Torkono, do you know who took her to the Court of Appeal? Mm. Do you know who took her to the High Court? She strained all the political parties. Mm. So this has nothing to do with whether she was appointed by MPP or NDC. What we all need to do is soberly reflect, and I'm sure if a prima facie determination is made, we'll all have the benefit of knowing. Look, in the case of Charlotte Osei, and remember that when Charlotte Osei matter happened, Frank Ajechum had already been decided. As at the time, Nana Addo Dankwa Akufo-Addo forwarded the Charlotte Osei petition to her ladyship Chief Justice, I think Sofa Akufo, right? And she made a prima facie determination. What was it on? Procurement breaches. I remember at that time, I cautioned. I said, no. Superior Court judges, because of the countervailing force in our democratic experiment, right? The grounds for their removal should be something very serious. At that time, my friends in the MPP, my friends in the MPP said, no, it matters not. Procurement breaches is enough, and that constitutes stated misbehavior. I said, look, the Procurement Act itself envisaged the possibility of violation and provided in Section 90 the opportunity to rectify. Yes. And so, in the wisdom of the maker of the law, they envisaged a situation where there could be mistake. So they said, set up a committee, investigate the matters. If the committee now makes... So I was looking at a situation where before you can remove a judge, it should be on grounds that he has stolen public funds. There's some, you know, some... Our friends in the MPP said no. And I remember, and I said this with so much sadness. Kweku Baako issued a writ at the Supreme Court. Yes. His lawyer was Samson Ladi Ayenene. That day, I happened to be at the Supreme Court with my senior Dr. Ayene on a different matter. That same day, the Charlotte Osei suit came, Kweku Baako suit came up. His Lordship Justice Nana Megache asked Samson Ladi, Samson, are you saying that a breach of the Procurement Act is not a violation of a law, is not stated misbehavior? And that was it. That day, I left the court sad. I said, look, if we put it in that context, all of us become vulnerable. The level of vulnerability is high. But I think at that time, it was convenient for some people to do that. Possibly because it was Charlotte Osei. And I've always maintained that tomorrow is pregnant. The accounts have been saying, yes, oh, you are for son. Now, why a day? Why should one son? Look, why is Afenyo Makin panicking? Does he have the benefit of the petition and its content?
Well, there's been some references made to some allegations that they, by minority, purport to be in the petition, which they describe in words as frivolous. In fact, the current Swami Member of Parliament, John Darko, addressed the press this week, referencing some allegations purporting to be in the petitions against the Chief Justice, and the description given to those allegations that they are frivolous. I want us to take a listen to because this, by the process and details of Article 146, the details of the petition is supposed to be in camera, secret. We shouldn't know. So then again, the reference is made of the allegations.
My learned senior says we are told. Now, when the president had the benefit of the petition, and the Chief Justice wrote the request, the president, in honoring the request, sealed the petition before giving it to her. Who informed the minority of the details? If her ladyship, the Chief Justice, in communication with the minority, because at this point, the petition is between the president and the Chief Justice. And in fact, for the president to guide the integrity of the process, he sealed, he marked the petition. I've heard one other journalist on Metro refer to what they claim to be the content of the petition. Who leaked to them?
That is, if it the
details. No, but this one he phrases that we are told.
Yes.
Who told
I listened to him carefully.
No, I just played that.
Who told him these contents? But you see, how come that he, John Darko, his own colleague, Afenyo Markin, Frank Anodompre, brought a petition for the removal of Loretta Lamptey. President Mahama didn't say it was an MPP MP against my appointee. He received the petition, actioned it, he found merit, and dismissed his own appointee. How come that today, Anodompre and his minority do not have confidence that President Mahama would do same thing he did to Loretta, affording her the opportunity to defend herself? Where is the fear? Where is the panic? You see, the stand of the minority relative to this broader national issue actually betrays a certain thing. It is extremely revealing. What is it? In all these constitutional arrangements, there's only one person under Article 146 to perform that role of receiving a petition. It is not Professor Ranford Jampo. It is not my learned friend here or this big man, not even me. Only President. The President. Who is the President of Ghana? Possibly the petitioner should have addressed it to the MPP minority
before
and given it to Afenyo Markin so that Afenyo Markin can consult the Council of State in this process. Malene Senior, you were called to the bar before me, and I've always been inspired by your legal work. What exactly is the complaint against John Mahama? My senior John Darko, what exactly is the complaint against President Mahama? Now, when you assume the position of now deciding that a petition is frivolous, are you not usurping the powers of President Mahama and the Council of State? Lawyer Darko, it is rather your conduct that is unconstitutional. It is rather your conduct that is unbecoming of a lawyer. President Mahama so far has only conducted himself within the confines of the law. Akufo-Addo did it. The three commissioners of the Electoral Commission were all removed through that process. President Mahama has not invented a new rule. He's just basically holding fidelity to the 1992 Constitution. I think at this point, the minority must stay away and allow President Mahama to perform his constitutional responsibility. If there is any merit, and I've always said, thankfully, the Council of State has a retired Chief Justice on that committee. Her guidance, and in fact, thankfully, she even is in a very interesting situation. You know why?
Relationship.
No. Charlotte says Prima Facie determination was made by who?
By her.
By her. So if there's anybody that has that experience, she'll bring that experience to bear. What did she see? In fact, if she's somebody who could make... Yes, if she could make a Prima Facie determination for the removal of Charlotte on her own, or even that one on her own, because remember that the process is different. If it comes to the Chief Justice, it's a different rule. But for other Superior Court judges, it's the Chief Justice that makes that determination. And she found it that in the case of Madame Charlotte Osei, the evidence of breaches of the Procurement Act was enough to warrant the establishment of the 5-member committee chaired by His Lordship Justice Benny. Has President Mahama done otherwise? No. So away from this, complete red herring. But it is actually an emotional conversation now. Because you see, CSOs, you must stand for the judiciary.
I'm here, I will speak.
Has President Mahama, look, as we speak, President Mahama, has he appointed any judge?
No.
Has he appointed any judge?
No.
So where from the interference? Has President Mahama asked that a particular judge should sit on a case involving him or his government? No. If there was any evidence of judicial interference, kindly look at the African peer review report in 2004. Yeah. No, 2005, even though it reflected 2004. Okay. When the Chikata trial, the fast track composition, where in the midst, President Kufuor appointed Justice Afre to the Supreme Court and got onto the panel that reversed the original fast track decision. The African peer review mechanism report indicted the president as directly interfering in the judiciary. President John Dramani Mahama does not have that reckless record. So where is the conversation going?
Okay.
President Mahama, on the 7th day of January 2025, in taking his oath, said, I shall respect the 1992 Constitution. What Afenyo Makin and his micro minority are doing is to say President Mahama disobeyed the Constitution, which will now be a ground for his removal. Because remember that if the president disobeys the constitutional order, that's grounds for his removal. Indeed. At this point, with all the counsel available to President Mahama, he is fortified not to obey that recklessness, but to stick to what the Constitution says. Right. Let's see what the coming days will reflect.
Indeed.